When we start for the UPSC Prelims preparation, every aspirant faces the same dilemma. Where should I start from? With a vast syllabus which covers literally everything under the sun and countless strategies, what truly works? The answer lies in the exam itself, that is, previous year questions. My name is Dalit Soni and welcome to the first episode of UPSC Prelims PYQ analysis series by Drishti IAS. In this series, we are not just going to discuss answers but understand why a particular option is correct and why others are wrong and how to eliminate the tricky choices. With detailed explanation, clear concept and elimination techniques, we will master the game of PYQs. So let's begin with the first episode here. We will be talking about the polity first. Okay. So if you look at these trends over here in the last few years, you will be seeing that almost 12 to 15 question has been asked from this section. Okay. If you are lucky, they can go beyond 15 as well. But when we are talking about the general trends, you will be seeing that 17, 12, 13, 7, 15, 12, 16, 17. So basically, you can say that somewhere around 10 to 15 questions has been asked in this particular section of the syllabus. And if you are lucky, sometimes 21, 23. Even if we talk about 2024, you will be seeing that there were 19 questions from polity section. Okay, so that is why polity becomes important for you. This is something which you cannot miss. Okay, now when we talk about the UPSC syllabus, you cannot miss anything, but you have to give extra focus to some subjects. Okay, so polity is one among them. Okay, now when we talk about the various sections among the polity, it is a vast syllabus and various subsections are there. But if we talk about the core areas, UPSC has this tendency that they will be asking you many questions from the core areas and they will be touching the periphery sometimes. Okay, so when we talk about this particular section over here, you will be seeing that, see, introduction to the constitution, 24 question has been asked from 2008 to 23. Along with that, there are some questions from the 2024 as well. So nearly 25 questions has been asked from this particular section. Then coming to the next one, citizen state relations, basically fundamental rights, fundamental duties, DPSP, etc. So you'll be seeing that more than 30 questions has been asked. Okay. Now coming to the next one, union executive and the legislature. When we talk about the sections like union government, prime minister, council of minister, parliament, etc., you will be seeing nearly 60 questions has been asked. Okay, so these are some of the areas which are your focus areas or your core areas where you have to give in extra efforts. Okay, then coming to the next one over here, Indian judiciary, local self-government. Every year you will be seeing that one or two questions has been asked from this section as well. Coming to the next one, constitutional posts and bodies and the non-constitutional and the statutory bodies. So basically they are talking about the bodies over here. So every year you will be seeing that there will be one question from this particular section will be there. And then governance and the reform, 30 question has been asked in last few years. So you can say one or two questions will be there from this section. Now the thing is, we are talking about these sections. These are your core sections. Okay. Now in the core itself, we will be seeing that there is a trend that UPSC will give you a question and there will be 4 options over there. One of them will be correct, but the 3 are wrong. But the thing is, these wrong options are also hints for you that they might ask you from these arena as well. So that is how UPSC is giving you a hint that they might ask you these questions as well. So now let's start with the discussion and we will be starting with the question number 1, which is concerning with the introduction to the Constitution of India. We'll be going theme wise and try to make a pattern out of it. Okay, so let's see the first question. Who was the provisional president of the Constituent Assembly before Dr. Rajendra Prasad took over? So Dr. Rajendra Prasad was the elected president. Okay, before that there was one president which was made on the basis of a French tradition. Okay, when we talk about the French tradition, so there the speaker or the, you can say, the president is basically selected as the, you can say, senior most member of the that particular membership. Okay, so here Dr. Sachidanand Sinha was the senior most member and he was selected as a president before the Dr. Rajendra Prasad took over. Okay, so that is something which is there. Option D would be your right answer over here. That is a fact which you should know. Now what I'm trying to say to you is that this question was asked in 2024 and there were 4 names which were mentioned. Okay, that is C. Rajgopalachari, you know that is a prominent personality from modern India. Then Dr. B.R. Ambedkar, that is, you obviously you are familiar with this particular name. Okay, and coming to the next one, that is V.T. Krishnamachari. Now some of you might not be able to recall this particular name. Okay, there were 2 vice presidents to the Constituent Assembly at that point of time. One of them was V.T. Krishnamachari. Now since you are not familiar with this name, it is your duty to read about this particular person, because this is given in the option. There might be a chance that UPSC will ask question from this particular personality as well. Okay, So that is how what I'm telling you is that if there are 4 options, then you should know about these 4 options as well. Okay. Now coming to the explanation part over here, the Constituent Assembly first convened on the 9th December 1946 with Muslim League boycotting the session because they wanted a separate nation, that is Pakistan. Okay. So they actually boycotted the session. Okay. Now what was the other body which was there in prominence? The Indian National Congress. Okay. Coming to the next one, as a result, only 211 members attended. Dr. Sachidanand Sinha, the oldest member, was chosen as the temporary president following the French custom. Okay. Subsequently, Dr. Rajendra Prasad was elected as the president of the assembly, which you know. Then you will be seeing that 𝐻𝐶 Mukherjee and 𝑉𝑇 Krishnamachari were elected as the vice presidents, giving the Constituent Assembly 2 vice presidents at that particular point of time. Okay. So now these names, 𝐻𝐶 Mukherjee, 𝑉𝑇 Krishnamachari, you should remember these names as well. Okay. Now coming to the next part. Before moving further, I would like to tell you that in your process or in your journey of UPSC prelims, we are offering you IAS Prelims GS plus CSET online courses where validity will be of 2 years, 500 plus hours of lectures will be there, unlimited watch time will be there within the validity, and then 30 free tests for GS as well as CSET will be provided for medium English we are talking about here. If you have any kind of doubt with respect to this particular you can say course, or you want to take this course, or anything you want to know about this particular aspect, you can call on this number, that is 87501 87501. Again, I'm telling you, if you have any kind of doubt with respect to you can say our products, or you can say whatever courses, magazines, or the test series what we are providing, if you have any kind of doubt, you can call on this number, that is 87501 87501, or you can download the Drishti Learning app. Okay. Now let's move further. The next question is, the Constitution 71st Amendment Act 1992 amends the 8th schedule to the Constitution to include which of the following language? Konkani, Manipuri, Nepali, and Maithili. Select the correct answer using the codes given above. Now the thing is, codes given below. So options are given over here. Now they are talking about a particular language. When we talk about official language, we have one schedule, that is 8th schedule. Now they are telling you that they will be asking question from the schedules. Okay, we have different schedules, we have different parts of the Constitution. You should know about them. Now they are saying that in the Constitution Amendment, that is 71st Constitution Amendment, so which of the languages were added? Okay. Now, when we talk about the Constitution Amendment with respect to the official languages, there were 3 Constitution Amendment which has happened. First was your 21st, okay, that was somewhere around in 1967. Then there was 71st, which we are talking about over here, okay, that was there in 1992, and then the third one was 92nd, that was 2003. Now, when we talk about the Maithili one, that was the latest one, which was added in the 92nd Constitution Amendment Act in 2003. So, when we are talking about the 71st one, so here you can say the 3 languages, Konkani, Manipuri, and Nepali, that were added. When we talk about the 1967, Sindhi was added. Okay. So that is something which you should remember. And recently also the official languages, this topic has been in news because in Maharashtra, Marathi has been made mandatory for the government communications in the government offices, etc. So because of that also this particular topic can be important for you. Okay. So that is there. So here Konkani, Manipuri, and Nepali, option A would be your right answer over here. Now related facts, let's talk about them. See, Part 17 of the Indian Constitution deals with the official languages. Article 343 to 351, it lists the official languages of the Republic of India. Okay, so that is there, something which you should remember. Then coming to the next one, 8th schedule of the Constitution specified 22 languages. Okay, originally there were 14 languages and now there are 22 languages. We call them scheduled languages. Okay, that is there. Sindhi was added by 21st Amendment Act of 1967, which we have talked about. Then Konkani, Manipuri, Nepali were added by the 71st Amendment of 1992, and Bodo, Dogri, Maithili, Santhali were added in the 92nd Amendment Act of 2003. Now, this is something which you should remember with respect to the official languages. These are the languages which are there in the 8th schedule. Okay, so Assamese, Bengali, Bodo, Dogri, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Maithili, Malayalam, Manipuri, Marathi, Nepali, Odia, Punjabi, Sanskrit, Santhali, Sindhi, Tamil, Telugu, and Urdu. These are the languages which are your scheduled languages. One homework would be there for you if you want to really prepare for this examination. These articles, you should go through these articles once. Okay, I'm not telling you to remember them. I'm telling you to go through them. Okay, so that is something. Highlighted part are the one which has been added later. Okay, so if you can see over here, Sindhi is there, that was added in 1967. Then coming to the next one, that is your Konkani, Manipuri and Nepali that were added in 1992. And when we talk about Bodo, Dogri, Maithili and Santhali that were added in 2003. Okay, I hope that is clear. Now coming to the next part, that is schedule of the constitution. You have to know the schedule of the constitution here. Originally in 1949 when constitution was enacted, there were 8 schedules. Now there are 12 schedules. Okay, various amendment has been carried out, that is 9th, 10th, 11th and 12th. So different schedules has been added through these or you can say these 9th, 10th, 11th and 12th schedule has been added through the various amendments since 1951. Now if we talk about the first schedule, second schedule, third schedule, I'll not go into details of all these things because you must have read about all these things in your static. So you can go through this. Okay, so when we talk about the first schedule, article 1 to 4, that is talking about the state, union territories and their territorial jurisdiction. When we talk about the second one, so here emoluments, allowance, privileges of the various constitutional posts has been discussed over here. Third schedule, if we are talking about, so here you will be seeing that the forms of oath and affirmations are given over here. Coming to the fourth one, that is allocation of the seats in the Rajya Sabha. Fifth one is related to the administration and the control of the scheduled areas and scheduled tribe. Sixth one is for the administration of the tribal areas in the state of Assam, Meghalaya, Tripura and Mizoram. That you should remember, that ATM2, that is Assam, Meghalaya, Tripura and Mizoram. These are the four states where the tribal administration is kept under the sixth schedule. Okay, coming to the seventh one, here you know that we have this you can say different lists which are there: state list, union list and the concurrent list which is there. We will be discussing about that. That is given in the seventh schedule. Then coming to the next one, 8th schedule, we have just seen that there are languages which are given. Okay, we are having 22 scheduled languages. Okay, 9th schedule, that is talking about the validation of certain acts, that is there. When we talk about the some of the acts are kept under this and for which judicial review was not there before the Keshwanand Bharti. Okay, so that was something there which was there in the 9th schedule. For that, one important case is there, that is the 𝐈𝐀𝐒 case is which is there, which is mostly discussed with the 9th schedule. Okay, coming to the 10th schedule, that is talking about the anti-defection law. When we talk about the time where this Ayaram Gayaram policy was there. Okay, so that horse trading etc was there. In that regard, there was this 52nd Constitution Amendment Act in 1985 that brought the anti-defection law, which is under the 10th schedule. Coming to the, basically you can say that some of the disqualifications are there in the 10th schedule. 11th schedule, if we talk about, so that is power, authority and responsibility of the panchayat. 12th schedule is about the power, authority and responsibility of the municipalities. I hope that is clear. These are your 12th schedule which you should by heart. Okay, coming to the next one, parts in the constitution. So there are different parts which has been given over here. Okay, now there are, you can say, total 22 parts which are there. Okay, part 1 is related to the union and its territories. Second part, if we talk about citizenship, simply if you have to remember, when we talk about the government, there are different organs of the government. First is the territory. So in the first part we have discussed the territory. Okay, coming to the second one, that is population. Population has been discussed in the citizenship. Okay, so second part is citizenship. Third is the fundamental right. Now here, if population is there, that means that you have to give some kind of benefit to them and their duties will be there, so that fundamental rights. Then fourth part is the EPSPs, and 4A, which was added later to the 42nd Constitution Amendment Act, that was fundamental duties. Okay, then there is the fifth part that is talking about the union executive. Then we have the sixth one, that is state executive. Seventh has been omitted from this, and then we have the eighth part, that is union territories. Then when we talk about ninth, that is panchayat. Ninth A is municipalities. 9B is basically cooperative societies. 10th is the schedule in the tribal areas. So like that, there are different parts which are there which you should remember. Okay, so that is something with respect to the parts of the constitution. Okay, now here you can see there are some official languages which are there in the 17th part, which we have already seen, and question has been asked about it, so you should remember that. Coming to the next one, when we talk about the elections, that are there in the 15th part. When we talk about the emergency provisions, that are there in the 18th one. When we talk about the amendment, that is there in the 20th one. So these are some of the important things which you should remember. Okay, now coming to the next question, which of the following statement are correct about the Constitution of India? Powers of the municipalities are given in the part 9A. I told you that if they are asking you schedule, they will be asking about the parts as well. Okay, so that 9A, we just have seen that in the 9A, that is municipalities. Okay, so that is correct. Coming to the next one, emergency provisions are given in the part 18. So here you can say 18 emergency provisions are there. Provisions related to the amendment of the constitution are given in the part 20. Okay, so that is given in the part 20. So all the statements are correct over here. Option D would be your right answer. Okay, so 19A is talking about the that particular, you can say, part was added through the Constitution Amendment Act, that is 74th. When we talk about the 73rd, okay, that is your panchayat. Then 74th is basically your municipalities. Okay, so that is there. Article 368, which is there in the part 20, that is dealing with the amendment of the constitution, process related to the amendment of the constitution, that is there. Okay, it states that the parliament may amend the constitution by way of addition, variation or repeal of any provision in accordance with the procedure laid down for this purpose. Okay, so that is article 368. Coming to the next question, which of the following statement is or are correct as per the Constitution of India? Now, interstate trade and commerce is a state subject under the state list. Now, they are talking about the state list. As I told you, that is there in the 7th schedule. Okay. In the 7th schedule, there are 3 lists. One is your union list, then there is state list, and then there is concurrent list. Okay, so when we talk about the union list, union government has power to make law. When we talk about the state list, state government has power to make law. And when we talk about the concurrent list, both of them can make the power make the law over there. But if there is a central law which is there, so central law which will prevail if there is a conflict between the center and states law. Okay, so again I'm telling you, if there is a law which is there in the or there is a subject which is there in the concurrent list, if there is an entry which is there in the concurrent list, and now state has made a law and the center has made a law, okay, in that case what will happen? If there is a conflict, then the central law will prevail. Okay, and if in that particular case, if the state government get the assent of the president, then the state law will be valid over here. Okay, so that is about your schedule 7. Now let's see what they are talking about. Interstate trade and commerce is a state subject under the state list. Now they are talking about the interstate trade and commerce. That means that more than one states are involved. Then how is that one state can make a law? So that might not be a possible answer. Okay, when we are talking about the UPSC, they says that you have to choose the most appropriate answer. Okay, coming to the next one, interstate migration is a state subject under the state list. Now again, if there is an interstate migration, that means that from one state to second state people are migrating, then why is that only one state can make a law? So again, that cannot be true. Okay, coming to the next one, interstate quarantine is a union subject under the union list. Now when we talk about quarantine, okay, you must have seen at the time of the, you can say, COVID, we have gone for the quarantine, etc. Now you have to, if there is a medical emergency or the health related emergencies are there, in that case you can see that there can be a power which can be with the government. Okay, so Indian government, because we have to make sure that if there is a pandemic, that do not spread. So that is something serious which can be there. So again, here they are saying that the interstate quarantine is union subject, and again it is the interstate. When more than one state is involved, there it makes sense that it can be under the union government. Then coming to the corporation tax is a state subject under the state list. Now again, it is not a state subject, it is also a union subject. Okay, so option C would be a right answer. That is talking about the interstate quarantine is a union subject in the union list. Okay, so even if you don't know the answer, that where these, obviously there are 96 entries or more than that entries in a particular list, so how can you remember all the entries? Okay, but the thing is, common sense says that if they are talking about the interstate trade and commerce, more than one state is involved, how is that one state can make a law? Okay, so like that you can eliminate these three options. Option C would be your right answer. Okay, so here, 7th schedule of the constitution contain a 3 list. One is your union list, that is having 98 subjects. In the union list originally there were 97, so here you can see there was an increase in the number of subjects. Okay, coming to the second one, state list has 59 subjects. Originally there were 66 subjects, so here you can see there is a decrease in the number of subjects which are there in the state list. Okay, coming to the next one, concurrent list has 52 subjects, and concurrent list has the 52 subjects. Originally it had 47 subjects, so here you can say that the number of subjects has been increased. Okay, so again, here you can see that the state list has seen a decline. Other than that, union and the concurrent list number of entries has increased. That means that more power has been given to the centers over here over the years. Okay, so state can make law over here, but again, if there is a conflict, the centers law will prevail. Okay, so that is something which you should remember. That is kind of a trend which you should remember. Okay, then it is given in the article 246 with respect to the 7th schedule, or you can say how the division is there. Okay, so here, Constitution of India, if we talk about, there are 3 lists which are there in under the schedule 7. Here you can see union list, state list, and the concurrent list. Here subjects like defense, atomic energy, foreign affairs, war and peace, banking, railways, post, telegraph, airways, ports, foreign trade, currency, and the coinage, these are under the union list. Union government can make the laws. Now again, see, these are all the important topics. which are under, you can say, union government. Coming to the next one. Now, agriculture, police, prison, local government, public health, land, liquor trade and the commerce, livestock and the animal husbandry, state police services, these are under the state list. Now here you can see these are something in which you need to have an idea about the region specific things. When we talk about the agriculture, when we talk about the police is the job of the police is to maintain law and order. You need to know about the local situation, then only you will be understanding the law and order over there. So that is why agriculture, police, prison, local governments, that is your panchayats and the municipalities, all these things are kept under the state list. Okay, coming to the next one here, concurrent list, that is having, you know, subjects like education, transfer of property, and then forest, then trade unions, adulteration, adoption and succession, all these things are under the you can say concurrent list. So both union and state can make laws, but the, you can say, law of union will prevail over here. Now those subjects which are not under these three lists, okay, so that is your residuary subjects which are there. So residuary powers are, you know, with the, you can say, central government or the union government over here. Okay, so that is about your schedule 7. Here when we are talking about the question, so entry 42 is talking about the interstate trade and commerce, that is a union list. Then interstate migration, interstate quarantine, corporation tax, all of them are the union list subjects. Entries are 42, 81, 81, 85. Okay, I hope that is clear. Now let's move further to the next question. With reference to the Government of India Act 1935, consider the following statements. It provides for the establishment of all India Federation based on the Union of British Indian provinces and the princely states. Okay, so that is one thing. Coming to the second one, defense, foreign affairs were kept under the control of the federal legislature, that is basically your center. Okay, so both the statement here are correct. When we talk about the 1935 Government of India Act, most of the provision of the Indian Constitution has been taken from the Government of India Act 1935, because that was a very long, you can say, document. So most of the administrative procedures has been taken from the Government of India Act 1935. Now again, if they are asking you about the Government of India Act 1935, there are high chances that they might ask you about the you can say whatever registrations which are there, which can be important, like when we talk about the charter acts, etc. So that can be asked, but again, that is the subject of modern India. So we will be discussing that in the modern India. But here Government of India is important. Government of India Act 1935 is important because that is some of the one of the direct source from which the constitution has taken the administrative procedure. Okay, now as I told you, option C would be a right answer. Government of India Act, if you talk about the provisions over here, it provided for the establishment of the All India Federation consisting the provinces and the princely states as unit. Provinces are the one which was under the British rule, and then we talk about the princely states that were there under the princes over there. Okay, it introduced bicameralism in 6 of the 11 provinces. At that point of time, 11 provinces were there, and out of them 6 were introduced with the bicameralism. Then it was categorized, subjects were categorized over here, like there were 3 lists, like the 7th schedule. So again, you can see that we have 7th schedule which is having 3 lists. Okay, so here also in the Government of India Act 1935, there were 3 lists which were there: central list, state list and the concurrent list. Okay, so you can see the resemblance over there. Coming to the next one, federal list, which is there, it is having the 59 items at that point of time. So these were all the topics of the national significance, like defense, foreign affairs, finance, railways, currency and the press, which are still under the, you can say, union list. Coming to the next one, that is state list, that is having 54 items at that point of time. These were of the regional importance. Okay, like I discussed earlier. So here education, medicine, agriculture, law and order and the local governments, still these are the topics which are there in the state list. Coming to the next one, concurrent list, there were 36 items: electricity, marriage, divorce, labor, criminal laws, etc. And the residuary power over here was with the Governor General. Okay, so that is about the Government of India Act 1935. Okay, now moving further, consider the following statement in respect of the Constitution Day. Okay, statement 1: the Constitution Day is celebrated on the 26th November every year to promote the constitutional values among the citizens. Absolutely correct statement. Coming to the second one, on 26th November 1949, the Constituent Assembly of India was set up a drafting committee under chairmanship of Dr. B.R. Ambedkar to prepare the draft Constitution of India. Now they are saying that on this particular day they have set up the drafting committee. But again, if you know the preamble, you will know that this was the date on which we have given ourselves the constitution. So that by that time, constitution was already ready. Okay, so that is why this statement becomes incorrect. Okay, so statement 1 is correct and the second one is incorrect. Here you can see statement 1 is correct and the second is incorrect. Option C would be your right choice over there. So if you remember this particular date, that is there on the preamble. Okay, and there it says that, here you can see, in our Constituent Assembly on this day, that is 26th day of the November 1949, do hereby adopt, enact and give to ourselves this constitution. That means that constitution was already ready. Okay, now it is your job to by heart the preamble. Okay, so here, we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity to promote among all, then fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So other than that, this part I have already told you. Here what it tells you, that first, we the people of India, that these are the sovereign people over here. Okay, and we are making India into a sovereign, socialist, secular, democratic republic. So here the nature of the state is also being given. Okay, coming to the next one, what we are giving to our citizens. So basically justice, liberty, equality and fraternity. Okay, so this is something. And other than that, they are telling you on which day we are giving this gift to the citizens. Okay, so that is basically your Constitution of India's preamble, which is quite important. Question has been asked earlier, you will be seeing in the discussion that question has been asked. This particular topic, liberty, is kind of been favorite topic of UPSC in the last few years. Okay, they are asking questions with respect to the liberty and the constitutionalism again and again. Okay, now Constitution Day is celebrated on 26 November every year. On this day in 1949, the Constituent Assembly formally adopted the Constitution of India, came into force on 26 January 1950. That is from where we have started to celebrate our Republic Day. Okay, then when we talk about when the drafting committee was set up, that was 29th of August 1947. Drafting committee was set up under the chairmanship of Dr. B.R. Ambedkar to prepare a draft of the Constitution. Okay, so that is about this particular question, and now we can move further. In essence, what does due process of law means? Now in the last few years, what we have observed, that they are asking you about the topics, like they are asking about the concepts like due process of law, they are asking about liberty. Okay, they are asking you about constitutionalism. Okay, they are asking you about what does the constitution, what is the job of the constitution. Such questions has been asked again and again, so now we have to focus on that as well. Now in essence, what does due process of law means? The principle of natural justice, that can be true. Coming to the next one, procedure established by law. Now when we talk about the procedure established by law and the due process of law, these are two different terms. Okay, so how is that? If there is a two different terms, that means that there will be some kind of difference. Okay, so that cannot be your answer. Okay, because they are asking about the due process of law, and we know that there is a difference between the due process of law and procedure established by law. So there can be some difference. Okay, so that is your choice, which you can eliminate. Fair application of law and equality before law. Now when we talk about the equal protection law of the law and the equality before the law, these are altogether different concepts. When we talk about the right to equality sector, then we discuss all these things. Okay, now fair application of law and the principle of natural justice, that can be there. Now when we talk about the due process of law, in that fair application can be part of it, but this particular you can say term is broader than that. Okay, there are other aspects which are there. So when we talk about the principle of natural justice, option A would be a right answer. And what they are saying over here is that principle of natural justice means that there are certain principles which cannot be denied at when you are talking about the justice. Okay, so that is about the principle of fair, equity, equality, all these things are there. And you can say when we are talking about the chance to give a proper hearing, all these things are there in the principle of natural justice. Now when we talk about the due process of law, what they are saying is that a process has been followed. Okay, and they will also check the rationality of the process. Okay, when we talk about the procedure established by law, that means that you are taking away any kind of right, and there is a procedure for that. Okay, and you have followed the procedure. Now when we talk about the procedure established by law, if that has been challenged in the court will only see whether there is a law and the procedure which is given in the law has been followed or not. That's all. Okay, but when we talk about the due process of law, they will also see the rationality of the law, whether law itself is correct or not. Okay, so that is due process of law. That is a broader concept. Okay, coming to the answer over here. So natural justice implies fairness, reasonableness, equity and equality. Okay, fairness, reasonableness. They will also talk about the reasonableness of the law. They will explore the law as well. Natural justice is the concept of the common law. It is the common law word counterpart of the American concept, that is procedural due process. Okay. Now coming to the difference between the procedure established by law and the due process of law. So it implies that a law that has been duly enacted by the legislature, that means that a person who has the authority, or a body who has the authority, they have enacted the law. That is one thing. Whatever law is there, there are few process which has been given in the law, which rules are there in the law, whether these rules are followed or not. Okay, so that is basically the procedure established by law. So it implies that a law that has been duly enacted by a legislature or the concerned body is valid if only it is followed in the clear procedure. Okay, correct procedure has been followed. Following this doctrine means that a person can be deprived of a personal liberty even if life according to the procedure established by law. That is what is there written in the article 21. State can take life as well if there is a procedure established by law. That is the rationale which is given behind the capital punishments as well. Okay, then hence if the parliament passes a law, and the personal liberty or in the life of a individual can be taken off according to that particular procedure and the provisions. Okay, so that is procedure established by law. Coming to the due process of law. Due process of law is a doctrine that checks for the law depriving life and the personal liberty of an individual, and checks if the law is fair and not arbitrary and just. They will look into the law. Here they will look that whether there is a law or not. They will see the law, if it is there, is it fair or not. Okay, so they will go into the reasonability of the law, fairness of the law. Okay, so that is due process of law. In India, when we talk about, so article 21 says that there is a right to life and liberty, which is there as per the procedure established by law. So it is written in the letter, it is written that procedure established by law, but when we talk about the spirit, we follow due process of law. We go into the reasonableness of the law as well. That is the doctrine of judicial review, wherein we check the fairness of the law. Okay, so that is there. Coming to the next one over here, that is, which of the following statement best reflects the chief purpose of the constitution of a country? What is the purpose of the constitution of the country? That I told you that they are asking you conceptual questions recently. So this is something which has been asked in 2023. So let's see. It determines the object of for the making of the necessary laws. Now, when we talk about the constitutionalism, law can be made by the executives as well. Okay, why is that? We are talking about specifically of the constitution. Coming to the next one, it enables the creation of the political offices and the government. Now there is a institution, that is Niti Aayog. Okay, Niti Aayog is not made by the constitution, it was made by an executive order. Okay, so basically we can say that without constitution also, with an executive order you can make a institution. So that statement is also wrong. It defines and limits the power of the government. Okay, now this can be right, because constitution is a book wherein all the things are given, and you have to work within that particular framework. That means that the powers of the governments are curtailed over here, that you cannot surpass the constitution, you cannot violate the constitution. Okay, so that can be your option. Coming to the next option over here, it secures social justice, social equality and the social security. That can be done by different ways as well. But when we talk about the constitution, that has the chief purpose, or the you can say most important purpose, that is to make sure that government do not exceeds its power. So that is, it defines and limits the power of the government. Option C would be your right answer over here. Okay, constitution serves as the supreme law of the land and provide framework for the governance and ensuring the balance of power, protecting individual rights and guiding the functioning of the states. The chief purpose of the constitution is to establish fundamental principle, structure and the function of the government, and define the rights and the freedoms of the individual within the country, which exactly India's constitution does. That there are checks and balances, there are, you can say, limits which has been there is separation of power, there is division of power. All these things are there so that governor, you can say, the government do not exceed its power. Okay, coming to the next one, what was the exact constitutional status of India on 26th January 1950? Now they are talking about the 1950 original preamble. You know that there was you can say changes which has been made in the preamble. So let's see. A democratic republic? No. A sovereign democratic republic? That can be there. Sovereign secular democratic republic? Secular was the word which was added later, and the socialist was the word which was added later. So we can say that C and D cannot be your answer, A is not your answer, so option B is your right answer, a sovereign democratic republic. Here you can see the Constituent Assembly on 26 November 1949 adopted the constitution. We have already talked about that. So constitution status of the constitution on the 26th January 1950 was sovereign democratic republic, which was changed to sovereign socialist secular democratic republic on with the 42nd Constitutional Amendment Act 1976. Okay, so that is there. Now, if you look at the preamble over here, you will be seeing that is the original preamble, which is saying that the sovereign, democratic, and republic. Okay, and here if you see, so sovereign, socialist, secular, democratic, and republic. So these two words has been added later. Other than that, also here you can see this word over here, unity and integrity of the nation. This has also been added with the 42nd Constitutional Amendment Act. Earlier, it was not there. Okay, so these two changes has been done with the 42nd Constitution Amendment Act. 42nd Constitution Amendment is the Amendment Act is the most important because there are various changes which has been made over here, and you can say significant changes. Fundamental duties has been added on the recommendation of the Swaran Singh Committee, and then preamble was changed over here. So we can say that 42nd Constitutional Amendment Act is, for a reason, it is called as the mini constitution. Okay, moving to the next one. Which of the following factors constitutes the best safeguard of liberty in liberal democracy? A committed judiciary, committed to whom? If it is committed to government, then it cannot be, right for a particular country that all the aspect or all the policies which government is, bringing. Judiciary is committed to the government and judiciary is approving them. So that is against the independence of the judiciary. So we cannot say that that is a, you can say, right choice over here. Coming to the next one, centralization of power. Centralization of power will lead to the, you can say, make sure that a one institution or the one government at the center, that basically become very strong. Okay, so that is also not true. Elected government, okay, and then separation of power. Elected government makes a country a republic. Okay, it has nothing to do with the safeguard of the liberty. No doubt somewhere it is there, but we have to go for the, you can say, most appropriate answer, that is separation of power. Separation of power means that all the organs of the government will work in their own sphere. Okay, so that is there. So we have executive, we have legislature, we have judiciary. Okay, they are having separate, you can say, powers, they are having separate responsibilities. And in Indian constitution you will be saying that there are some checks and balances, okay, which is there. That means that will safeguard the liberty of the individuals. If executive is, surpassing their line, so here judiciary will tell them to go back. Okay, so that is the idea behind over this particular question, that is separation of power is the right answer. Okay, so liberal democracy represents is a representative form of the government that operates under the following principle: separation of power, then rule of law protected by the independent judiciary. So independent judiciary is one of the element. Equal protection of the human rights, civil liberties, political freedoms for all people, separation of power between the different organs of the government. Okay, so these are the, you can say, pillars of the liberal democracy. Then coming to the next one, doctrine of separation of power, which I have already told you, that if there are, you can say, different organs, there will be a separation and they will be working in their own sphere. And if the Constitution of India, when we talk about the Constitution of India, that basically allows to have a little bit intermixing over there. You will be seeing that judiciary has something to do with the legislature as well. Judiciary has something to do with the executive as well. When you talk about the appointments, the role of executive will be there in the appointment of judiciary. All these things are there. So this is to make sure there is a check and balance. Okay, it minimizes the possibility of arbitrary access by the government, since all the three branches act as the checks and balances on the power of each other. Okay, coming to the next one, in context of polity, which one of the following would you accept as the most appropriate definition of the liberty? Okay, so protection against the tyranny of the political ruler. Now for that, different, you can say, protection can be there. Okay, so this cannot be the most appropriate one. Let's see the other one, absence of restraints. Okay, mostly if you talk about the liberty or freedom, you will be seeing that there should not be restraint. Okay, but the thing is, there cannot be freedom, absolute freedom. If there is absolute freedom, let's say Mr. A has been given absolute freedom, no restraint is there, so he goes and kill Mr. B. Is that liberty? No, that is not liberty. Okay, so that is the idea is there, that this person has liberty in his sphere, this person has liberty in his sphere, but there are some reasonable restrictions which are also there, which makes sure that this person does not violate the rights of this person, so that both of them can develop fully. Okay, so coming to the next one, so this cannot be the answer. Opportunity to do whatever one likes, that again, that is the absence of all the restraint, whatever one likes, so that is something which cannot be the answer. Then coming to the opportunity to develop oneself fully. Okay, so that can be your answer, that liberty is not just, absence of restraints, this is also an opportunity, so that every person develops themselves fully, so that you can say there is an element that there are reasonable restrictions, that one cannot, violate the rights of other. Okay, so that is about liberty, opportunity to develop oneself fully. So liberty broadly means ability to do as one pleases. Generally, it means like that. The preamble of India is giving you liberty of thought, expression, belief, faith, and worship. Why? These elements will help you develop fully. Okay, so that is there. But the constitution also put reasonable restrictions. Okay, so that does not mean that when we are talking about the ability to do as one please, that does not mean that that is absolute. Okay, there are some reasonable restrictions which is there. Okay, and why is that? That is to develop a person fully. Okay, now let's move further. Committed judiciary, I have already told you, this is something which we have discussed in the last question. Okay, so committed to whom, that is also one of the aspect. If we talk about the judiciary which is committed to upholding the policies of the government, that means that it is going against the independence of the judiciary. Centralization of power we have already seen, separation of power we have already seen. Now coming to the next one, we adopted parliamentary document democracy based on the British model, but how does our model differs from the that particular model? So as regard legislation, the British Parliament is supreme or sovereign, but in India, the power of Parliament is to legislate is limited. Obviously, Constitution is there, so there is some kind of limitations is that you cannot violate the fundamental rights. Okay, you cannot violate the Constitution, so that is there. So that is one thing. Coming to the second one, in India, matters related to the constitutionality of the amendment of an act, the Parliament are referred to the Constitution bench by the Supreme Court. If there is a issue which is related to the matters of the constitutionality, the Supreme Court can refer it to the Constitutional bench. Okay, so that is also true. Option C would be your right answer over here. Okay, so let's see. Parliamentary sovereignty means supremacy of the legislative body. Whatever that body wants to do, they can do that. So that is there in the UK. If we talk about, so parliamentary supremacy is there. But when we talk about India, India has constitutional supremacy, that whatever is there in the constitution, that is supreme, you cannot violate that. Okay, so here parliamentary supremacy is not there. Constitution is the law of the land. Okay, so we have to follow the constitution. So in India, we have supremacy of the constitution. There is a written constitution, distribution of the legislative powers between union and states, fundamental rights are there, judicial review is there, and independence judiciary is there. That is ensuring that the parliament does not do anything which is violating the constitution. Now if there is a law which is having any kind of conflict with the constitution, okay, in that case there can be judicial review. Okay, and if there is a matter which is having some kind of you can say conflict with the constitution, that can be referred to the constitutional bench. A constitutional bench is the bench of Supreme Court having 5 or more judges on it. Constitution benches are exceptions, set up only if one or more of the following circumstances are there. If there is a question or the case which is involving substantial question of the law pertaining to the interpretation of the constitution, that is given under Article 145(3) of the Constitution. Okay, so here a bench can be set up, and that bench cannot be less than of the 5 judges. Okay, so that is there. Coming to the next one, if President of India is asking for some kind of opinion from the Supreme Court under Article 143 on the question of law or the fact, then they can set up it. 2 or more 3 judge bench. If there is a 2 or more 3 judge benches which are there and which are having some kind of conflict over a particular situation, then a 5 judge bench can be there, so that that conflict can be resolved. Okay, on the same topic, if they have given different judgments, okay, then a 5 judge bench can be resolving that particular issue. Okay, now if you can say a later 3 judge bench doubts the correctness of the judgment delivered by a previous 3 judge bench. Okay, so let's say there was a judgment in 2005. This was given by a 3 judge bench. Okay, and in 2006 there was this 3 judge bench which is not agreeing with this particular opinion. Then also there is a constitution bench which can be set up which is having 5 or more than 5 judges. Okay, so that is about this. Constitutional government means, what does the constitutional government means? A representative government of nations with federal structure, a government whose head enjoys the nominal powers, a government whose head enjoys the real powers, a government limited by the terms of the constitution. Option D is your right answer, which we have already discussed in the previous question when we were talking about the constitution. Okay, a constitutional government is defined by the existence of the constitution, which may be a legal instrument or merely a set of fixed norm or the principle generally accepted as the fundamental law of the polity, and that effectively controls the exercise of the political power, that is your government. Okay, a parliamentary system of government is one in which all political parties in the parliament are represented in the government. Okay, that can differ basically on the kind of parliamentary system you are having. So accordingly that can be there. Then coming to the next one, government is responsible to the parliament and can be removed. Now this is something that is the core feature of the parliamentary system, that government is responsible, okay, and that can be removed as well. Okay, so option B would be your right answer over here. The government is elected by the people, that is basically more of a republic they are talking about. Then coming to the next one, government is chosen by the parliament but cannot be removed. Now that cannot be the answer to the parliamentary system. Option B would be your right answer over here. Okay, so you can go through this. Article 75 of the Constitution is basically talking about Indian kind of parliamentary system, wherein the collective responsibility is there. When we talking about the Lok Sabha, there is a collective responsibility. Okay, so here you can see the Council of Minister is collectively responsible to the House of People, that is Lok Sabha. Generally speaking, you can say that there is a collective responsibility to the Parliament, but specifically speaking, you can say that the collective responsibility is there to the Lok Sabha. Okay, so there can be a no confidence motion and government can topple. Okay, so that is there, which is one of the constituent of the parliamentary democracy. The rules of the Lok Sabha provides a mechanism for testing the collective responsibility. They allow any Lok Sabha MP who can garner the support of 50 colleagues to introduce a motion of no confidence against the Council of Ministers. If the no confidence motion is passed, the Lok Sabha will be dissolved. Okay, so that is the collective responsibility. Coming to the next one, which part of the Constitution of India declares the ideals of the welfare state, DPSPs? That is a simple thing. When we talk about the fundamental rights, these are basically your political and the civil rights. When we talk about the DPSPs, these are your socio-economic rights which are there, which are not enforceable in the court of law. Okay, now moving further, directive principle of state policy that are given under article 36 to 51. Okay, so you can go through this. This is something which is very basic, that is your you can say static part. Okay, here you can see, consider the following statement: the Constitution of India defines the basic structure in terms of the federalism, secularism, fundamental rights and democracy. Coming to the next one, the Constitution of India provides for the judicial review to the safeguarding the rights of the citizens, or you can say citizen liberties, to preserve the ideals on which the Constitution is based. Okay, so basically they are saying that the Constitution of India defines the basic structure. Now that is not true, because basic structure doctrine is the something which has come up with the 𝐾𝐲 Bharati judgment. So that is something which is judicial innovation and not given in the Constitution. The Constitution of India provides for the judicial review. Now Constitution of India does not provide for the judicial review. There are, you can say, some of the articles which are which you can say that these are the basis of the judicial review, but again exclusively, or you can say in the explicit terms, it has not mentioned the judicial review in the Constitution. Okay, so option D would be your right answer over there. Okay, so here you can see 𝐾𝐲 Bharati versus State of Kerala, that is 1973's case, which is the case which basically provided that Parliament can amend any part of the Constitution, but they cannot amend or change the basic structure of the Constitution. Okay, so that is there. And coming to the next part over here, that there is no direct and the express provision in the Constitution empowering the courts to go for the judicial review. Implicitly, you can say that Article 32, Article 13, these are there, but explicitly it does not mention that. Okay, coming to the next one, the preamble of the Constitution of India is part of the Constitution but has no legal effect, not part of the Constitution but has legal effect, and no legal effect either. Then a part of the Constitution has the same legal effects as any other part, a part of the Constitution but has no legal effect independently of other part. Here you can see, if you talk about the preamble, so this is basically the part of the Constitution. In the various judicial judgments, it has been said that it is part of the Constitution, but it does not have legal effect independent of any other part. Okay, if there is another part which is talking about certain things, then yes, we can give a legal effect to that. But if there is no such law or the part which is there, so independently you cannot go to court for the enforcement of the preamble. Okay, so option D is your right answer over there. Okay, so here in the cases, that is 𝐾𝐲 Bharati in 1973, it was said that the preamble of the Constitution to be considered as the part of the Constitution, preamble is not the supreme power, or the preamble is not the supreme power or the source of any restrictions or prohibition, but plays an important role in the interpretation. What is the role of the preamble? That if there is a doubt, okay, so we will be looking into the preamble to see the intent behind the you can say a particular provision in the Constitution. Okay, so that is for the interpretation, it can be there, but otherwise independently it does not have a legal impact. Okay, so in the Union Government versus LIC of India, in that case also they have reiterated the same position. Okay, so that is about the preamble. Now, before moving further, ISGS foundation courses are there for your integrated preparation for prelims and mains. Okay, key features are 1000+ hours of the classes, unlimited view time is there. Prelims test series will also be provided under integrated within this particular course. Okay, medium of language here will be English. For more details, you can call us on 87501 or you can download the Drishti Learning app now. Okay, now coming to the next part, that is citizen state relations, fundamental rights and the duties. Okay, under which of the following article of the Constitution of India the Supreme Court of India placed the right to privacy? Okay, so Article 21 is the right answer over here. Right to privacy, that K.S. Puttaswamy judgment which was there. Okay, so here in 2017 there was this judgment that K.S. Puttaswamy versus Union of India, right to privacy was included as a fundamental right. Now Article 21 is the most important article in the Constitution because it is, having a non-exhaustive list. Okay, so when we talk about Article 21, so you will be seeing that there are various rights which are, given under Article 21 by the judicial interpretation. Okay, so here one is your, right to privacy. Other than that, if you talk about the right to marry to a person of your choice, that is also under Article 21. If we talk about right to health, that is also under Article 21. If we talk about the recent one, that we have a right against the effects of the climate change, that is also under Article 21. Okay, so that is there. Consider the following statement. According to the Constitution of India, the central government has a duty to protect the states from the internal disturbances. Okay. The Constitution of India exempts the states from providing legal counsel to a person being held under the preventive detention. When there is a preventive detention, then they can, say that there is no legal counsel can be provided for that. So this is also correct. When we talk about the statement one, that is also correct. Then coming to the next one, according to the Prevention of Terrorism Act, that is POTA 2002, confession of the accused before the police cannot be used as evidence. Now, in general, if we talk about the law, or you can say if we talk about the CRPC sector earlier, criminal laws. So in that, if there is a confession which has been made in front of the police, that will not be treated as an evidence. A confession in front of the judicial magistrate only can be considered as an evidence. But when we talk about the you can say act like Prevention of Terrorism Act, etc., in that a confession given to police will also be considered as evidence. Okay, so this statement is incorrect. 1 and 2 is correct, so option B would be a right answer, that is only 2. Okay, you can go through the same thing which we have discussed just now. When we talk about the preventive detention, Article 22 clause 1 and Article 22 clause 3 and subclause B, that will be important. It guarantees the right to legal counsel. When we talk about the Article 22 clause 1, it says that a person which is arrested or which is involved in any crime, that should be given a legal counsel. But when we talk about the Article 22 clause 3 subclause B, it strip away the right from a person arrested or detained under the preventive detention. Okay, that is there. In 𝐴𝐀𝐒 𝐏𝐫𝐞𝐴 case, it was stated that the detainees do not have right to legal representative or cross examination in the advisory board hearings, that is basically during the preventive detentions. Okay, the acts like terrorist and the you can say disruptive activities prevention act, that is TADA and POTA, in such cases evidence, or you can say a confession which is given to the police, that will also be considered as the evidence. Okay, now let's move further to the next one. Under the Indian Constitution, concentration of wealth violates the right to equality, directive principle of the state policies, right to freedom and the concept of welfare. Okay, so option B is your right answer. When we talk about the concentration of wealth, that is state has duty to ensure that there is no concentration of wealth. So that is your directive principle of state policy. Okay, so directive principle of the state policies which are given under the Article 36 to 51. Okay, and here when we talk about the Article 39, so there are some of the rights which have been mentioned over here. You can go through these rights. Again, this is a static part. This is something you have to read, and you can say you can so make sure that you do not forget this. Okay, now when we talk about the DPSPs are divided into three parts. One is your socialist principles, then second is your Gandhian principles, and third is your liberal intellectual principles. So when we talk about the socialist principles, it is the promote social order, minimize inequalities in the income and the status and the opportunities. When we talk about Article 39, right to adequate means of livelihood, equal distribution of the resources, prevention of the concentration of wealth, equal pay for the equal work, like that, these are the rights which are there. Free and legal aid to the poor, which is also there. Coming to the next one, Article 41, that is talking about the right to work, education and the public assistance. Then Article 42, just and the human condition of the work. Then Article 43, that is talking about the wages and the decent standard of living for all workers. Article 43 is talking about the participation of workers in the industry. Then Article 47 is talking about the raise at the level of the nutrition and the public health. Okay, this is something which you have to read and memorize. There is nothing you can do about it. Then coming to the Gandhian principles, Article 40, that is talking about the village panchayat. Then 43 is talking about the promotion of the cottage industry in the rural areas. Then Article 43, that is talking about the cooperative societies. Now they have been given a constitutional status with the 97th Constitutional Amendment Act. Okay, so that is there. That is under Part 9B. Okay, so that is something you can remember. Article 46, that is talking about the education and the economic interest of the SC, ST and other backward or the weaker sections. Then Article 47 is talking about the prohibition of the consumption of intoxicating drinks and the drugs. Article 48 is talking about the prohibition on the slaughter of the calves and the cattle. Now liberal intellectual, if we talk about, so this is something which is important. Article 44, UCC has been in the news for various reasons. Okay, and Uttarakhand has actually adopted this now. So that is something you should remember. Article 45 is talking about the early childhood and the care for the education of the children, that is of the age 0 to 6 years. 86th Constitutional Amendment Act, which you should remember. Then likely there are some of the articles which you should remember. Then Article 50 is important, that has been asked previously in the examination, that is separation of judiciary from the execution. Okay, so that is about your DPSPs. Coming to the next one. What is the position of right to property in India? It is a legal right available to citizen only? No. It is a legal right available to any person. Yes, it is a legal right which is available to any person. It is not a fundamental right. Earlier it was a fundamental right, then it was removed from the list. Then neither fundamental nor legal right. So it is not the case, because it is a legal right under Article 300A. Okay, so that is something which you should remember. Our right to property was under Article 31 and Article 91F, and it has been removed and put under Article 300A of the Parts 12. Okay, so that is there. Now it is a legal right and not a fundamental right. It was done by 44th Amendment Act 1978. Okay, so that is there. Here you can say citizens' right to own property is a human right. State cannot take possession of it without following the due procedure and the authority of law. Therefore, it can be concluded that right to property is a legal right available to every person. Okay, coming to the next one, a legislation that confers the executive or the administrative authority an unguided and the uncontrolled discretionary power in the matter of application of law violates which of the following article? Okay, so they are saying that if there is a discretionary power, and if there is a unguided and uncontrolled discretionary power is there, then it will violate which article? Okay, if we talk about Article 28, that is to do with, you can say, your freedom of religion, etc. Okay, coming to the next one, Article 32, that is the remedies which are given. Okay, so that is also not true. When we talk about Article 44, that is about UCC. So Article A, Article 14, that is option A, that is the right to equality. That is talking about that there should not be any privileges or the discretionary power given to someone. Okay, so that is Article 40. So equality before law and the equal protection of law. No person shall be denied the treatment of equality before the law or the equal protection of law within the territory of India. Okay, so every person should be given equality before law and equal protection of law. Therefore, Article 14 acts as the shield against any kind of arbitrary or the discretionary state action, and court may declare a law ultra vires if that is against the Article 14. Okay, Article 28, I have told you about, it is over the freedom of religion, freedom over religious instruction or religious worship in the education institution. So that is there. Other than that, Article 32 is the constitutional remedies we have already seen. Article 44 is about the Uniform Civil Code. Okay, so you can go through these things. We will be uploading the PDF of this particular session in our Telegram channel, and the link will be provided to you in the description. So don't worry about that. Okay, moving further. With reference to India, consider the following statement. There is only one citizenship and one domicile. Second, a citizenship by birth only can become the head of the state. A foreigner, once granted the citizenship, cannot be deprived of it in any circumstances. Okay. So if we talk about the first one, there is only one citizenship, that is true, and one domicile. Domicile is basically the place of your origin, of where you are basically based. Okay. So that is something which cannot be changed. Okay, so statement 1 is correct. In India, we have only one citizenship and one domicile. Coming to the next one, that is citizen by birth only can become the head of state. Now, these terms like only, or you can say under any circumstances, these are some extreme terms which are there. Okay, so here you have to be cautious. I'm not saying that they will always be wrong, but what I'm saying is that you have to be very careful while dealing with such words. Okay, so a citizen by birth only can become the head of state. Now, this is not true. By birth or naturalization can become the head of the state. Foreigner, once granted the citizenship, cannot be taken, deprived of the citizenship in any circumstances. Now, that is also extreme statement. if there are, there are certain situations where that foreigner can also be deprived of the citizenship, it is once it is granted to him. Okay, so this both of them is incorrect. Only one, option A would be a right answer, that is only one statement is correct over here. Okay, domicile is the permanent home. Okay, for a person that will be only one permanent home. Article 9, if we are talking about, so that is about your, if any person voluntarily acquire the citizenship of foreign state, will no longer be the citizen of India. That means that only one citizenship will be there. If you are acquiring any other state's citizenship, that means you are losing India's. Okay, so that is single citizenship and one domicile. Okay, article 58, if we talk about, so no person shall be eligible for elections as president, that is head of state of India, unless he is a citizen of India, has completed age of 35 years and he is qualified for election as the member of House of the People. And Article 58 signifies nowhere that citizenship should only by the birth or naturalization. Similarly, to become a prime minister, a head of the government, one has to be a citizen of India, irrespective of by birth or by the naturalization. Okay, and he should be a member or qualified to be a member of the Lok Sabha or Rajya Sabha. Okay, so that is about the you can say this particular question. Coming to the next one, here you can see there are 4 ways which are listed under the Citizenship Act 1955 through which Indian citizenship can be acquired. So there are 4 ways: birth, descent, registration and the naturalization, and the provision related to the termination are also provided in the same act. Okay, section 10 is given. So in these circumstances you can terminate the citizenship of a person. Here you can say the citizen has disrespected the constitution, has obtained the citizenship by fraud, or the citizen has unlawfully traded or communicated with any enemy during the war. So these are the circumstances when your citizenship can be terminated as well. Coming to the next one, within 5 years of the registration or the naturalization, a citizen has been sentenced to 2 years of imprisonment. If a person has been sentenced to 2 years of imprisonment within the 5 years of the registration, then also he can be denied the citizenship. The citizen has been living outside India for 7 years continuously, except for the purpose other than the education or service of the government or international organization of which India is a member, or he has not registered annually at the Indian consulate expressing his intention to retain his citizenship. In that case also his citizenship can be terminated. Okay, so this is about citizenship. These are the provisions which you should remember, I guess. Okay, other than that also there is a Citizenship Amendment Act 2019. Okay, so under that some provisions are there which also you should remember. Coming to the next one, right to privacy is protected under which article of the Constitution? We have already seen, that is article 21 of the Constitution. You don't have to worry about this. Moving further, in India, separation of judiciary from the executive is enjoined by preamble of the Constitution, directive principle of the state policy, 7th schedule, or the conventional practices. Option B is the right answer. We have just seen that article 50 is the one which is talking about the separation of judiciary from the you can say executive. Okay, so here you can see article 50 is given. So again, if you know the DPSP, that is the core area, so they are asking you question again and again. Okay, moving further, which one of the following categories of the fundamental rights incorporates protection against the untouchability as a form of discrimination? That is against the right to equality. Option D would be a right answer. That is given under Article 17. Okay, so that is there. Here, from Article 14 to Article 18, these are under the right to equality. Okay, so here you can see there are 6 categories of fundamental rights. One is right to equality, 14 to 18, right to freedom, that is 19 to 22, right against the exploitation, that is 23 24, right to freedom of religion, that is 25 to 28, cultural and education right 29 30, and right to constitutional remedies, article 32. Okay, so that is there. Here if we talk about article 17, that is talking about the untouchability. So abolition of untouchability has been talked about in article 17. Okay, it abolishes the untouchability and forbids its practices in any form. The enforcement of any disability arising out of the untouchability shall be an offence punishable accordance with the law. Okay, so that is there. Moving to the next one, with reference to the provisions contained in the part 4 of the Constitution of India, which of the following statement are correct? They shall be enforceable by court. When we talk about the part 4, they are talking about the DPSPs. Okay, again DPSP they are asking. Okay, so they shall be enforceable by the court. So DPSPs are not enforceable by the court. Okay, they are enforceable by the law. If there is a legislative statute which has been made by the parliament, then it can be enforceable. Without law it cannot be. So they shall not be enforceable by any court. That is right. Coming to the next one, the principle laid down in this part are to influence the making of the law by the state. So these are the directive principles of state policy. So basically these are the direction which has been given by the constitution to the state while you are making policy, you have to consider these directions. Okay, so that is correct. The principle laid down in this part are to influence the making of the law. Okay, so 2 and 3 is correct. Option D would be your right answer over there. Okay, so it is given over here. You can go through this. Whatever I have discussed over here, that is what has been you can say talked about over here. Okay, so when we are talking about the DPSPs, it is starting from 36 to 51, and then after that, when we are talking about the 51A, that is your fundamental duties. Okay, moving further, other than the fundamental rights, which of the following parts of the Constitution of India reflects the principle and the provisions of the Universal Declaration of Human Rights, preamble, directive principle of the state policy, and the fundamental duties. If we talk about the preamble, so you know that there are liberty, freedom, all these things are given over there. So obviously these are part of the human rights. Okay, so that is correct. DPSPs, these are the socio-economic rights. Okay, so that is also correct. Then fundamental duties ensures that there are some kind of rights which are given to the children, etc. Other than that, also fundamental duties ensure that a person or the citizen is respecting the rights of others as well. Okay, so that is something which is there. So all of them are having some kind of link with the Universal Declaration of the Human Rights 1948. So 1, 2 and 3 would be your right answer. Okay, so that is something you can go through this. Objective of the preamble such as justice, socio-economic and the political, equality, liberty, these are the principles which are there in the Universal Declaration of Human Rights. When we talk about the directive principle of the state policy, here you can see there are some of these are the socio-economic rights itself. Okay, coming to the next one, here you can see Article 38, promoting the welfare state, minimizing the inequalities, free legal aid, supporting the vulnerable sections. These are some of the reflection of the human rights only. Okay, when we talk about the fundamental rights, here you will be seeing that there is this article 51A subclause K, that is talking about the education of the child of 6 to 14 years, that is under the dignity of the children through the education. Again, that is also part of your human rights. Okay, moving further, which article of the Constitution of India safeguards one's right to marry the person of his choice? I have already discussed that, Article 21. Okay, option B would be a right answer. Okay, Lata Singh versus State of Uttar Pradesh. This is the case. If you can remember, that would be good. Okay, moving further, I would like to tell you that IAS prelims test series. Now we have discussed that PYQs. Now whatever is there in current affairs, okay, on the basis of that, practice becomes important. When we talk about the PYQs, when we talk about the current affairs, when we talk about the prelims preparation, practice is important. For that, test series are there. So we are offering you a prelims test series for IAS prelims test series 2025. Comprehensive coverage will be there, subject wise evaluation will be there, detailed explanation will be there. Okay, so for details you can call on this number, that is 87501, or you can download the Drishti Learning app. Okay, now with that we will be concluding today's session. Whatever is left, we will be coming up with the next episode. Okay, so we'll see you soon with the next episode. Till then, have a nice day. Thank you, and please subscribe the channel.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.